Hello, and good afternoon to all of you in Asia. Good evening for listeners in Australia and New Zealand. This is Mushtaq Kapasi, Head of Asia Pacific for ICMA. We welcome you to this virtual event on CSDR Settlement Discipline, Implications for Trading and Documentation in Asia Pacific. I'm glad to be joined by my two colleagues who are leading ICMA's global work on CSDR. Andy Hill, Senior Director and Head of Repo and Secondary Market Practice, and Lisa Cleary, Senior Director and Associate General Counsel of ICMA. So without further ado, I'd like to hand over to Andy to begin the presentation.
Thank you, Mushtaq. The approach we'd like to take with this webinar is essentially 4 steps. We're going to start by talking about the existing market remedies for settlement fails in the non-cleared bond and repo markets. We'll then look at the CSDR settlement discipline regime itself, the provisions and the scope. Third, we'll talk about how ICMA is looking to support implementation for its members and the work we're doing in terms of documentation. And then finally, and very briefly, we'll look at the potential implications for bond market functioning and liquidity. So I'll hand over to Lisa to begin with the existing market remedies.
Thank you, Andy. So notwithstanding the introduction of settlement discipline measures via regulation, the market has already developed standard mechanisms for dealing with settlement failures, at least for markets for which ICMA produces standard form documentation. ICMA rules and recommendations for the secondary market have for many years contained an industry standard buy-in mechanism to remedy settlement failures in OTC cash sale transactions in international securities. And many of you, I hope, would be familiar with those rules and recommendations. They apply to relevant transactions between member firms, but are frequently incorporated by reference to apply in member to non-member or non-member to non-member transactions. The rulebook contains settlement failure related mechanisms, including rules and recommendations relating to interest claims, buy-ins and sellouts. And these are existing remedies already used by the market. In the repo space, ICMA has sponsored the development of the GMRA, the Global Master Repurchase Agreement, for over 25 years, the most recent version being published in 2011. Again, I would hope that many of you are familiar with this documentation. And you will be familiar with the idea that the GMRA is a standard agreement for documenting cross-border repo containing provisions relevant to dealing with settlement failures. So either triggering early termination for a specific transaction, so-called mini closeout, as well as default event triggers for the termination of the entire master agreement. All this to say there are well-established, appropriately calibrated, existing contractual mechanisms used by the market to deal with settlement failures. So the key features of the ICMA buy-in mechanism used in the OTC cash markets are that if delivery is not made on the value date of a transaction, the ICMA buy-in mechanism provides the buyer with the right to issue the seller with a buy-in notice, designating a buy-in execution date. And within the current framework, that's at least 4, but not more than 10 business days following the date of the notice, on which date they will buy in the relevant securities elsewhere for guaranteed delivery. It's not necessary to appoint a buy-in agent, although this was traditionally the route used. We did make an amendment to the rules a few years ago that got rid of this requirement. In the event the buy-in cannot be completed on the buy-in execution date stated in the notice, then it rolls over to subsequent business days until complete or until the parties agree on another settlement form. Partial delivery is acceptable, subject to certain conditions, and key to the current setup is the fact that a buy-in may be passed on. So in the case of the same or multiple intended settlement dates, you only have one buy-in being executed to satisfy the whole chain. And this is a really efficient mechanism for reducing the number of buy-ins, but dealing with a chain of settlement fails. Also, in relation to the current setup, the money difference between the original contract and the closeout contract, so the buy-in contract, that is settled symmetrically. So whether the value goes up or down, the economics of the original transaction are preserved. Neither party is inadvertently disadvantaged or advantaged as a result of the buy-in. And this is a key point to remember where we take you through the CSDR buy-in. We also provide within the ICMA rulebook and the ICMA buy-in mechanism an equivalent sellout mechanism. And again, that's something to bear in mind when we lead on to talk about the CSDR buy-in mechanism. So in order to assist the market with CSDR implementation and compliance, ICMA intends to produce 2 sets of market documentation. One, an amended form of the ICMA rules and recommendations for the secondary market, the ICMA rulebook, and 2, a CSDR Settlement Discipline annex to the GMRA. In addition, ICMA is also looking at providing legal opinion coverage to support compliance with regulatory obligations relating to contractual enforceability in relation to both forms of documentation. Following the implementation of CSDR and the introduction of the mandatory buy-in regime, we considered whether a 2-phase approach might work for the buy-in mechanism. So the ICMA rulebook will continue to offer an industry buy-in framework featuring a pre-end of extension period buy-in, and the extension period is relevant to the CSDR regulation, but we'll come on to that. So the ICMA rulebook would contain a pre-CSDR buy-in and a CSDR buy-in. So in this first phase, in this pre-extension phase, you would be allowed to use a relatively similar mechanism to what you have today, and that would be at the discretion of the buyer to trigger. So we've referred to this so far as the PEP buy-in, the pre-extension period buy-in. And the PEP buy-in notice can be used on the day following the value date of the transaction. It would state that the buy-in execution must take place before the end of the relevant extension period. It would be for guaranteed delivery, as it is today, on the condition that the buy-in trade is cancelled if delivery is not made on the buy-in execution date. Cash settlement would be possible, as it is today. And again, key point to remember, the price differential would be settled symmetrically. The pass-on feature would be retained, but only for the same intended settlement date, because there will be such a squeeze on the timeline for this pre-extension period buy-in. And also, we would need to ensure that the transition to the CSDR buy-in process would be managed with no loose ends. So at the end of that pre-extension period, you would move into the CSDR buy-in phase. And here, the features need to be different because they need to reflect the regulatory requirements. So the CSDR buy-in would be issued on the day following the expiry of the relevant extension period. The execution would need to take place within 7 days of the end of that extension period. And as per the regulation, a buy-in agent must be appointed. We'll talk more to the difficulties of that in a moment. As I mentioned earlier, within the CSDR framework, the price differential is not settled symmetrically. But subject to regulatory guidance, we're hoping that we can make this a feature of the ICMA rulebook CSDR part, so that we deal with some of the unintended consequences of the impact of the regulation. So it's possible that we'll be able to provide for a symmetrical price differential payment. We're also looking at the possibility of providing for a pass-on mechanism, but under the regulation that is not provided for. So this is also subject to further regulatory guidance. I've just referred to the ICMA rulebook changes. Now, in terms of repo documentation, we're developing, as we mentioned earlier, the CSDR SD Annex. We're doing this in collaboration with ISLA, so that what is produced provides an efficient mechanism for SFT master agreement users in their efforts to comply with CSDR. We will publish this as an annex to the GMRA for bilateral incorporation by contracting parties, but we're also considering developing a protocol mechanism for multilateral amendment. We understand that there is a fairly significant lift in terms of document remediation, and so we want to make sure that we're supporting counterparties as much as we can. The issue we now face is that with a relatively limited amount of time left before CSDR takes effect, which is reportedly February 2021, but we'll talk a little bit more about that timeline in a moment. There's a lot of work yet to be done from a systems implementation perspective, but also from a documentation perspective. So the CSDR legal work stream, and you are all welcome to join that group if you would like, to join those calls and be part of the work progressing those drafts. They've indicated that they'll need at least 3 to 4 months lead time to undertake the contractual remediation work required by CSDR. In addition, we'll also require time to obviously produce and finalise the document, obtain legal opinions as to enforceability, and potentially establish the mechanisms through which contracts can be amended. So whether that's just a bilateral form or whether that's something more sophisticated in form of a protocol. The remediation work required by firms will obviously not only be relevant to OTC cash bond markets and repo documentation, which are the two areas that we look after, but also to securities lending, derivatives, and futures contracts. And this is a significant undertaking. We don't underestimate that. Firms are really looking for a solution which ensures or assists with compliance in the most efficient way. As per our efforts on the ICMA rulebook front, we had originally intended to deal with some of the more challenging impacts of CSDR, but by providing commercial enhancements to the regulation in the annex. However, this is not possible on particular issues. So, for example, the provision of a pass-on mechanism. We can't provide for these issues without clear regulatory guidance, because it would represent, I think, for the market a regulatory compliance issue. So as a minimum, we need to assist firms with compliance in terms of the documentation we look after. And it's clear that regulatory compliance, notwithstanding outstanding questions on scope in terms of the regulation, is necessary, but that commercial enhancements are regarded as essential to support market liquidity. So in relation to repo, there are a few mitigating factors. So the mandatory buy-in regime will only apply to repos with a term over 30 days. And I would note here that there is continued advocacy on open transactions and margin transfers. But leaving that aside for a moment, that duration scope limits the application. And so in addition to that, taking out a significant proportion of repo trading not being affected by the mandatory buy-in regime, it's also expected that parties will exercise their existing contractual provisions, so their mini closeout provisions, before the CSDR mandatory buy-in takes effect. Of course, this doesn't alleviate the Article 25 requirements for document remediation, but it may offer a route to avoid the imposition of the unsuitable mandatory buy-in mechanism. So we've published what I hope is a useful FAQ in relation to CSDR and the SFTs. The link is on the slide, and I'd really encourage you to take a look at that if you're coming to this for the first time. It will explain more about the scope and application and some of the difficulties we see in terms of the implementation of the regulation. So our advocacy efforts have been vast, and we've been involved on this file for a long time, Andy in particular. We submitted Q&As on what we regard as headline issues to ESMA. We've undertaken market impact studies to indicate the effects on liquidity. Those are listed and linked to here. We've authored numerous letters to the authorities, either under the auspices of ICMA or as a cross-association effort. We've also responded to the latest ESMA request for feedback on the CSDR, focusing our efforts on Article 7, so the settlement discipline aspects of Level 1. We continue to engage in constructive dialogue with the authorities to communicate our concerns as to the impact of this regulation, as well as proposing market solutions and enhancements, which I referred to earlier, which might overcome some of the more challenging aspects of the regulation. We do, in fact, have a call with ESMA straight after this presentation, where we hope to get more of an insight. We maintain the position that the CSDR mandatory buy-in regime should be suspended pending implementation of other settlement discipline measures, such as penalties, and a meaningful market impact study should be completed as part of continued industry outreach efforts. So I'll pass back to Andy.
And I will spend a few minutes just talking through the settlement discipline regime, the regulatory requirements, and the scope and provisions. So EU CSD regulation is essentially focused, as the name suggests, on CSDs within the EU, mainly the measures for authorization and regulating CSDs. And much of the focus is very much on prudential, organizational, and business standards for CSDs. However, embedded in that fairly hefty regulation is just a few pages, Article 7, which Lisa referred to, which is settlement discipline, measures to address settlement fails. And this has two main tenets: cash penalties and mandatory binds. The latter being the one that we're very much focused on, as you just heard from Lisa, and mainly because we do not see this as post-trade regulation, we see this as market regulation. In terms of timeline, the actual CSD regulation itself came into law in August 2014, so it's been around quite a while. The regulatory technical standards for settlement discipline, including mandatory binds, were not submitted by ICMA to the Commission until February 2016. There was a very lengthy process in trying to develop, particularly the mandatory buy-in provisions, given some problems in the level 1, which we will come to, in which, as Lisa tried to explain, we're very much focused on in the work that we're doing to support implementation. This was finally published in the official journal in September 2018 with a 24-month lead time. So technically, this should be in force within a few weeks. This should be in force from September 13th of this year. However, due to technicalities, particularly related to the CSDs implementing the penalty mechanism, this was, it's been proposed that this is delayed until February 2021. This has been accepted by the Commission, but not yet by the Council and the Parliament. However, we expect this to be a formality in the coming weeks. As also mentioned by Lisa, there is now a rumor that this will get delayed further, again, due to a technicality relating to implementing the penalty regime. So this would mean the entire package, including mandatory buy-ins, would get pushed out until February 2022. However, this has not been confirmed. So at the moment, the market is very much expecting February 2021 for implementation. So in terms of scope, the settlement discipline applies to transactions, all transactions that settle on an EU CSD. This includes the ICSDs. This includes Euroclear and Clearstream. Also, any transactions that are settled on an EU CCP. Now, this applies regarding of the domicile of the trading entity. There is a requirement under Article 25 that requires all parties in the transaction chain to have contractual arrangements in place to enforce the regulatory provisions in all relevant jurisdictions. This means if you are a trading entity based in the APAC region, but you are entering a transaction that settles on, or is expected to settle on, an EU CSD, including the ICSDs, you are in scope, and you will be brought into scope through contractual arrangements that will probably be put in place with your custodian or sub-custodian.
And Andy, this is Mushtaq. Sorry to interrupt. I just want to clarify the ICSDs are basically Euroclear Clearstream. So this would apply to all bonds that are cleared on those two.
Absolutely. So cash penalties will be applied at the CSD level. And essentially, any failed transaction on an EU CSD or ICSD will attract a penalty. And that will be passed on to the non-failing party in terms of compensation. This will be applied at the gross transaction level and are credited or debited to participants' accounts monthly. CSDs are not permitted to profit directly from the penalty compensation. So the penalty that's applied will be fully compensated to the non-failing parties. CCPs apply their own penalty compensation regime internally. The rates are calculated off the same reference price for each security, which is updated daily. And the rates are actually fixed by asset type. And they're quoted as an ad valorem fee and applied on a business day basis. These can be revised at a later stage. If we move to the next slide, you can see what those penalties are. And what we've done here as well is transpose those to an annualized equivalent rate. So you can see that for liquid shares, it's a pretty hefty fee. It's 2.5% annualized, 1 basis point of the value per day. For government bonds, it's a tenth of that, 0.1 of a basis point on the value of the trade, or an annualized rate of 0.25%. So the mandatory buy-ins, these are very different to the buy-in process that Lisa described a few minutes ago. The buy-ins are executed at the trading level, so similar to now. In other words, the trading entities are responsible for executing the buy-in. So this will not be the custodian. This will be the actual trading entity who's required to do this. A buy-in agent is required, and we can maybe talk a little bit about this later. But the non-failing party is expected to appoint a buy-in agent, and it must be triggered automatically. There is a set timeline. This is 4 business days after the intended settlement date for liquid equities. All other securities, including bonds, it's 7 business days. There is a mirroring timeline for completing the buy-in. Again, 4 business days for liquid equities, 7 business days for all other instruments, including bonds. And to make it clear, this means that in the case of bonds, after a trade has failed for 7 days, the non-failing party is required to appoint a buy-in agent and issue a buy-in notice. They then have 7 days to complete the buy-in, which includes executing and settling the buy-in. If the buy-in is not possible, there is the option for one more attempt. This is called the deferral period, which again would be 4 or 7 days. If that option is not taken or the deferral period is not completed, then it goes to automatic cash compensation. In other words, the trade is effectively cancelled and the trade is cash settled based on a reference price. As already mentioned, SFTs are in scope to the extent that they have a tenor of longer than 30 business days. We're not sure if open SFTs are in scope. There is a Q&A that we've submitted, as Lisa mentioned, requesting that they be out of scope. The payment is, as already alluded to, very different to the restorative payments under the ICMA buy-in rules, for instance. They are asymmetrical. We think this is largely due to an error in the level 1 text. And it means that the payment will only go from the failing seller to the buyer in the case that the price is higher. There will be no payment in the case that the price is lower. Now, economically, this is the equivalent of writing an at-the-money put option every time you sell the security, which then becomes active in the case of a buy-in. As mentioned, there is no pass-on mechanism. As it stands, every single fail requires its own individual buy-in. We have put a proposal to ESMA, a cross-industry proposal for a pass-on mechanism, which is based on the ICMA pass-on mechanism. That's currently with the Commission. We're not sure if it will be possible. But the most important point to take away is the fact that the buy-in is a regulatory requirement, which will become, in the case of in the case of the trading entities, wherever they are, whatever jurisdiction they're operating in, will become a contractual requirement. You do have to buy in your failing counterparty. You have no discretion. So I won't go through the details here, but this slide compares the ICMA buy-in rules with the CSDR mandatory buy-ins, which are, as we discussed, significantly different. And this creates a number of problems. We'll briefly discuss some of those problems. As Lisa mentioned, we've undertaken 2 market impact assessments, one in 2015 and an updated one in 2019, which has been part of our advocacy effort to highlight to the regulators and also to market participants the potential problems. The last impact assessment was based on the outcome of a piece of research we did into the state and evolution of the European corporate bond market, which was also in 2019, published in early 2020. There we asked sell-side and buy-side participants what factors, what regulatory initiatives or market developments did they think would have the most impact on bond market liquidity, European corporate bond market liquidity, whether positive or negative. And what came out of this quite clearly, quantitatively and qualitatively, was that the 2 biggest concerns of sell sides and buy sides operating in the European corporate bond market were the implementation of fundamental review of the trading book and further Basel III, Basel IV measures, which would restrict market making. But also, and in the case of buy sides, this was the biggest concern, the CSDR mandatory buy-in regime. And again, this is because of the very direct impact it has on market makers and their ability to provide liquidity. So we undertook a second impact study in 2019 where we surveyed sell sides, buy sides, but also repo and lending desks to try and get a sense of what this regulation would do for market liquidity. And we'll just run through some of the results. The first thing we were interested in was how prepared and how aware the market was. As you can see, there was a fair amount of planning for those who are already aware of the regulatory provisions and impact, particularly given that this does impact not only operational processes, but it changes risk management and it changes trading behavior. However, more alarming was the fact that there seems to be the view that there is very little or very limited market awareness in general. One of the things we were keen to find out was how this would impact pricing and liquidity provision. And these charts show the expected impact on bid-ask spreads across a range of sub-asset classes of bonds. And it's pretty clear that the impact is significant. Even for the most liquid securities and most liquid sovereign bonds, the bid-ask spread is expected to double. And this is essentially because bond markets are very much reliant on market makers and their ability to sell securities that they don't own. The risk created by mandatory buy-ins, which is compounded by the asymmetry, makes it very difficult for them to show offers. And as we move to the less liquid end of the bond spectrum, so once we start getting into IG credit, into high yield and emerging markets, it's not just a case of those bid-ask spreads widening, it's a case of will dealers show offers? And what we find is that they certainly become more reluctant to provide liquidity in those asset classes. We asked buy sides how they felt the regulatory provisions would affect them, and again, they are very much aligned with the sell side in terms of their expectations, and there is a broad expectation that this will negatively impact market efficiency and liquidity. Again, with the real pricing and liquidity impact being at the lower end of the credit spectrum. Now, as we mentioned, repos and security lending are only in scope to the extent that they have a tenor of 30 days or more. So in Europe, that would put, if we assume open trades are out of scope, that would put about 80% of the market out of scope of the regulation, where we could still rely on the provisions in the GMRA or the GMSLA in the case of fails, rather than being expected to undertake a mandatory buy-in. However, there is a connection between repo lending and the cash market. And if you lend out securities and don't get them back to cover an onward sale, you have very little recourse in terms of being able to pass on any buying costs through your contractual arrangements. So this becomes a deterrent to lending. And again, we see the same impact on repo and securities lending from this regulation, that pricing will change, particularly as you move to less liquid securities, credit, high yield, emerging markets, or, which is probably more likely the case, owners of assets will just stop lending them. We did look at possible enhancements, and Lisa has already discussed some of these in terms of the work that we're doing, both from an advocacy perspective and what we hope with a contractual perspective. So having a pass-on mechanism, being able contractually to settle the buy-in or the cash settlement symmetrically, this would help. Removing the need for a buy-in agent, for instance. One of the problems we have in Europe at the moment is there are no buy-in agents. Under the requirements set out in the regulation, only one entity has put themselves forward as a buy-in agent, which creates a problem given that you have to appoint one. But where market participants see more helpful solutions would be in changing the extension period, i.e. the time before the buy-in is required, or just removing the buy-in requirement altogether. And I think this is a very telling response. The large majority of the market, 80% of those that we interviewed or surveyed, felt that this would actually be damaging to investor protection. And the motivation for it is investor protection. So it was interesting looking at what might have happened had this regulation been in place during the recent COVID-19 crisis, as markets became volatile in March. In Europe, at least, as we moved to a lockdown situation and as trading and settlements moved out of their buildings to working from home, we had a massive increase in settlement fails. You can see the data from ESMA that effectively across all asset classes, the settlement efficiency declined by about 100%. So if you'd had a mandatory buy-in regime in operation at that time, given that you'd have to buy in equities in 4 days, bonds in 7 days, in a very illiquid market where prices were gapping and also where resources were stretched, it's fairly clear that this would have been not helpful. This would have compounded the market impacts and the market volatility. So this again is something that's being discussed and is something that should be a concern to market participants. Just wanted to make you aware that there are a lot of resources, as Lisa mentioned. We produced a lot of papers, FAQs, discussion notes on the regulation. These can all be found on the website, but for your convenience, we've also put them in the slide deck. And on the next slide as well, you have our contact details.
Thank you, Andy. This is Mushtaq again. So the first question that's come in for either Andy or Lisa, I think, is what are the regulatory penalties recourse on APAC firms or bond investors that have no EU presence if they do not undertake mandatory buy-in? Perhaps you need to clarify the question.
Andy, I'm happy to start, and please feel free to add. I think the point here is that there is a regulatory requirement that this is provided for contractually, and the expectation of the vast majority of counterparties who are preparing for this and who settle on the ICSDs mentioned, they will be importing the mandatory buy-in regime contractually into their documentation so that it is enforceable as a contractual right. Now, there are penalties built into the settlement discipline aspect of the regulation, which will continue to be applied where there is a settlement failure which is not dealt with. So that's one aspect, but in terms of regulatory penalties for non-compliance, that's also an aspect to be considered. Andy, I don't know if you want to add to that.
The only thing I would really add is it's worth remembering that in the level 1, the original thinking of the regulators was that to make sure that this was enforceable, it would be the CSD participants, i.e. the custodians, who would be responsible for the buy-in. It was only after this was passed into law that the regulators realized that this was an impossible ask and that it could only be done at the trading level. Hence, Article 25 and the enforceability, as Lisa explained, through contractual arrangements.
So to be clear, and Andy, Lisa, please feel free to respond, either counterparty is potentially at risk, either from a contractual perspective or even from a regulatory perspective, if they do not undertake the buy-in procedures. Is that right?
Yes.
Yeah, correct, yeah.
Okay. Just a follow-up question, and Lisa, this kind of dovetails from your answer just now when you talk about the bringing in the regulatory provisions into contracts. So Andy and Lisa, you've both described how this is being done by ICMA on 2 levels. One is in the cash bond market through the rules and recommendations, and then also in the repo market through the GMRA annex. Can you elaborate a little bit more about what exactly parties need to do for the relevant contractual documentation to be modified for each of these markets?
Sure, Andy, happy to take this first, and again, please feel free to add. So let's start with the ICMA rules and recommendations for the secondary market, so the OTC cash rules. Those rules are contained within the ICMA rulebook, and they are then either apply as a matter of membership between two ICMA member firms when they are entering into in-scope transactions. So these will be OTC cash transactions in international securities, and that is a defined term, so capable of cross-border settlement. So those rules will apply as between members, or they will be incorporated by reference where there is a non-member to member element. We'll often see these being incorporated into terms of business, and so they really sit as the market standard conventions for OTC cash markets. They form part of the contractual terms of the transaction, and so we would seek to amend those centrally by making an update to the ICMA rulebook and publishing that to the market. To date, they've only been available to member firms, but the intention is that once these amendments are made from a CSDR perspective, that rulebook will then be made publicly available to anybody. And that would make it far more efficient and easy for both members and non-members to reference, use, and access. So that from a documentation perspective is slightly more efficient because it operates in a quasi-protocol way. But of course, you would need to ensure that the incorporation by reference is suitable, valid, and enforceable, depending on the jurisdiction of the counterparties and various other factors to ensure that the formalities of contract formation are met. But that's a slightly easier way of dealing with the documentation aspect. From the repo perspective, from the GMRA perspective, and this extends to the GMSLA because we're working on this together, we're producing the CSDR Settlement Discipline Annex. And as I mentioned earlier, we will publish that in a bilateral form so that parties can individually and bilaterally negotiate that into their contracts. We would expect that on publication, that document is circulating very, very broadly, that the parties are starting to educate and familiarize their clients with the documentation such that they can implement that, they can incorporate that into their documentation suite, either on a bilateral level, or we are in discussions about whether we can do something more efficient. So whether we can provide for some form of protocol mechanism where you can apply this on a multilateral basis. So we have experience of this, of course, from the GMRA 2011 protocol, but the update of that was fairly limited. We haven't yet had in the repo market, and certainly not from a repo GMRA perspective, a regulatory imperative to any of the protocols that we've published. This would be the first time. And so I think whilst we're cautious about the uptake of protocols because we haven't seen that in our space previously, there are other trade associations who do this, on a regular basis, but this would be the first time we see a regulatory imperative. So it may be that there would be increased uptake of that form of mechanism because of the circumstances here.
Okay, great. We have a couple more questions. So the next question is, are there any criteria or eligibility requirements for the buy-in agent under CSDR? The questioner understands that CSD or custodians cannot be agents. Can you clarify this, please?
That's a very good question. I'm happy to take this one. Yes, the regulation, it doesn't say too much on the buy-in agent. This is all in the regulatory technical standards. There's no mention in the original regulation of a need to appoint a buy-in agent or any provisions around a buy-in agent. But in the level 2, it does state that you must appoint a buy-in agent and that the buy-in agent must have no conflicts of interest. So that then asks the next question, which is, what does conflicts of interest mean? And it's understood that this would rule out, for instance, custodians. It would rule out market makers who could all be seen as having a conflict of interest. which then narrows the scope for any potential buying agent. And as I mentioned, so far only one entity has put themselves forward as a buying agent. They're essentially a buy-in platform, which facilitates buy-in auctions, very much based on an equity CCP model. How this would work for fixed income, particularly less liquid fixed income, nobody is sure. It's not even certain that everybody could be able to operate with the sole buying agent. So it is a major issue at the moment. The fact that we are moving into a mandatory buy-in regime where the requirements include the appointment of a buying agent, there may not be a buying agent, then you end up in cash settlement. And cash settlement has its own problems. How do you find the reference price, a valid reference price for an illiquid security that probably hasn't traded since the fail? So it is a very problematic regime in that respect.
Okay, thank you, Andy. Next question. On cash penalties, is there a threshold amount for a potential waiver?
I don't believe there is. I think the CSDs calculate every single fail at a gross level, and then at the end of the month, they will then credit or debit the participants' accounts with the net amount.
Okay, so the cash penalties basically operate automatically.
Automatically, and that's absolutely, that will be done automatically by the CSDs.
Okay. One other general question that we've received independently is, you mentioned the survey results and the impact of CSDR mandatory buy-in, and in particular, you mentioned an adverse effect on investor protection. Could you elaborate on that a bit? Why does this regime actually harm the interests of investor protection?
It's a good point, and clearly the impetus behind it was to improve investor protection by reducing the number of settlement fails. The problem we have, particularly in the European market structure, is that bond markets rely heavily on market makers to provide liquidity. In fact, talking to market makers, it's estimated that about 30% of the offers they show in bonds are not based on X's. They are responding to an RFQ where they do not hold inventory. And their ability to do so is based on an assumption, clearly, that they can buy back those bonds or borrow them within a very short period of time. But there is an outlying risk that they may not be able to. And even if that risk is a very small percentage, those fails, which are not intentional, are unlikely to result in a buy-in. Buy-ins are incredibly rare. They do happen, and it's, as Lisa explained, it's within, if you trade under the buy-in rules, it is within your right to buy in your counterparty. But generally, these things are not triggered automatically within a few days. So now market makers are going to be put in a position whereby, even though these circumstances are outliers, in the case that they do fail for 7 days, they will face an automatic buy-in, and that buy-in could be incredibly expensive. So you're talking about less liquid securities where prices gap quite easily. You then have to put in the buy-in premium. There's a messaging signal that there is if you like, a distressed buyer in the market. There is normally premium attached for guaranteed delivery, which is implicit for a successful buy-in, and that premium is borne by the seller. So it's a huge deterrent to shorting securities, even if you think there is liquidity in the repo market, because if the repo fails, you have no recourse.
So
I should also add it's a deterrent to lending securities, as I mentioned earlier, for the same reason. If you don't get your securities back and you fail an onward sale, you will be bought in, and you have very little recourse on the failing repo.
Right. So while the original intention is to reduce fails, which sounds like a very good thing for investors, ultimately the end impact will be to reduce liquidity, and increase costs, which is clearly a bad thing for investors.
Yeah, essentially you move to a market structure that's based on guaranteed delivery, or where you don't hold bonds in inventory. It's trading by appointment.
Understand. So next question, do you expect non-EU trading participants to switch to non-EU related CSDs? Have you seen this happening? I'll let Andy and Lisa go with that first, and I can offer a partial answer, I think.
Yeah, I'm happy to start with that. With respect to, I mean, we haven't seen it yet. I guess we won't really know until after the implementation. But yes, there has been a lot of talk about, for instance, US denominated, dollar denominated bonds that can settle either in DTCC or on the ICSDs, and their liquidity fragmenting towards the US settlement system, which does make sense. So I think to the extent that securities can settle outside of Europe, you will see a two-tier pricing and a fragmentation of liquidity, which is unfortunate. But for European securities, which are limited to the European CSDs, then unfortunately that option is not available.
Yes, and I can add just very informally from Asia that I can't point to any hard data at this point. We haven't seen evidence of bonds kind of being moved to non-EU CSDs merely because of CSDR. That's very hard to track. Obviously, you can't really know the reasons for it, but it's certainly the case that the non-EU CSDs realize this may be an opportunity, and that it may be a more attractive, certainly from a repo and secondary market trading perspective, to the market for the securities to be cleared through non-EU governed CSDs. So this is something that theoretically certainly could happen, although we haven't seen evidence for it happening at this point ahead of the implementation of CSDR. If anyone in the market is seeing evidence to the contrary or evidence either way, of course, I'd personally be very interested to see it, and so would Andy and Lisa.
Mushtaq, I wonder if I could just submit my own question and answer it.
Please do. Please do.
I think it's just worth mentioning one more thing, and it links back to the question we've just had. The UK has already indicated that they will not be going forward with the mandatory buy-in regime aspect of their own settlement discipline legislation. And we also now find ourselves, at least informally, aware that there is potentially a planned delay to the implementation. So whilst we're all very busy working towards this February 2021 implementation date, there is a well-established rumor that, and we have, as I mentioned earlier, a call with ESMA after this to establish the basis of that, the idea that there will be a 1-year delay to the implementation of the regulation. Now, whether that means that there will be a significant change to the form and scope and the calibration of the settlement discipline aspects of the regulation, it's not clear. But parties should be aware that that's happening in the background.
Okay, thank you very much, Lisa. That's very useful, and I think that many on the audience, I think, will breathe a sigh of relief for that extra time. However, if I'm not mistaken, this is still signed into law. It has been since 2014, and it's not likely to be repealed as a matter of law. So while we can hope for further delay and to iron out some of the difficulties, there may not be a kind of permanent reprieve from this regulation.
Correct. And from a documentation perspective, it's unlikely that we are going to be able to take our foot off the gas at all because of the remediation period required. So I think, whilst perhaps the business end of things may breathe a sigh of relief in terms of the impact on trading and liquidity here, it doesn't necessarily take any of the pressure off from a documentation perspective. We may still need to push ahead. It's very likely that we'll need to push ahead with the Article 25 requirements because we may not get this confirmation of delay in time to do anything else.
Okay, thank you. And just for those of you listening, watching, we will be updating the market members and members very certainly, but to the extent we can, non-members as well, and other market participants on updates updates to the timetable, as well as updates to the planned JIMR annex and potential protocol. So one final question that we have time for. Will there be any party monitoring the non-execution of mandatory buy-in? In other words, who actually monitors the compliance or non-compliance there?
That is a really good question. As the regulation is written, the CSDs are supposed to report fails, and they're also, I think, expected to report whether the buy-ins happen or not. That I believe they are unable to do. That requires receiving information from the CSD participants. So it's a really good question. And I think it goes back to the original intention of the level 1 to make the CSD participants and even trading venues responsible for buy-ins. Now that it's pretty clear that this is not possible, that it is at the trading level entity, any monitoring would have to be done on a contractual basis through the settlement chain. I don't think it's possible that an authority in Europe can track this independently.
Thank you very much, Andy. Well, I'm afraid that's all the time we have for today. Please stay safe and healthy. Thank you very much.